This program is brought to you by Emory University.
So welcome everyone, and I'm really pleased to welcome Browne Lewis to the Feminism and Legal Theory Project and the Vulnerability and Human Condition Initiative. Browne is the Leon and Gloria Plevin Professor of Law and Director of the Center for Health, Law and Policy at Cleveland Marshall College of Law. And she's going to talk to us today about a really interesting topic involving reproduction and new innovative questions. Right.
Thank you. Good afternoon, and thanks everybody for coming out. Thanks, Martha, for having me, and Emily for coordinating everything for me. While I'm here, I want to research looking at posthumous reproduction. I've done some work on artificial insemination and surrogacy, and this was the next logical step in my research. I heard a news story yesterday about a man in Louisiana, where I'm from, who stored his sperm at a sperm bank with the hope that his wife would use it to conceive a child. And in the meantime, his girlfriend went to the sperm bank, and she got the sperm, so now he's suing the sperm bank. And he's suing the girlfriend, but he's still living. And so what I'm looking at in cases posthumous reproduction, and I'm defining that as using the gametes of a dead person to conceive a child. And I approach it from the lens of property and bioethics and estates and trusts, which are the courses that I teach. And I've divided the paper up into two portions. I focus on frozen sperm and I focus on fresh sperm, looking at the situations where, for whatever reason, is usually because somebody is being treated for cancer or with chemo or something that would leave them infertile. In the case of women, is that sometimes women are freezing their eggs for future use if they are not ready to have a child at that particular time. And I'm looking at what happens to if the person dies and the sperm is frozen, what happens to that sperm? Who has the right to the sperm? And from an ethical perspective and a legal perspective, how do we treat that sperm? Do we treat it as property? Because if we treat it as property, then under the intestacy system, it would go to the next of kin. Do we treat it utilizing the Moore case when it says that you don't have a property interest in your tissue in your body once it is removed from your body? Do we treat it as organs, which means if you don't have the donor card, do we go to the family and say, do you think he would want his sperm to be removed? And I look at cases where the man has left instructions and cases where the man has not left instructions. And those instructions in looking at the cases have taken two forms. One is testamentary instruction. There's the Hedge case where the man leaves a will saying that he would like his sperm to be left to his girlfriend, and he would like for her to use it to conceive a child, and he even writes a letter to the child. And then there's a fight between his existing children and the girlfriend. And the court in that case treats it just like property. You can leave it in your will just like you can leave anything else. Another case is involved when they leave instructions, but it's written instructions on the form with the sperm bank when they donate the sperm, and the sperm say, in the event that you die or something happens, what do you want us to do with it? And there was a case in Wisconsin where the man and his wife, they wanted to have a child, so they froze his sperm because they were going to do in vitro, and he passes away. And then the wife discovers that he's filled on the form saying, in the event of my death, discard the sperm. And so she sues for the sperm, and the court ends up siding with the clinic, saying that it's his sperm and he has a right. And she's saying that even if it's treated as property, as the wife, I should get it because I have an elective share. At least I should get some of it. But the court didn't buy that argument. But I think that those cases are relatively easy because the man has given direction about what he would like to have done with his sperm. And even, I think, cases where the man that hasn't left a clear direction, that it's almost a presumption if he stores the sperm that he's worried about infertility, that he has no problem with somebody using the sperm to procreate, uh, to conceive a child. I think the harder question are the cases when we're dealing with what I call fresh sperm, is when the person hasn't stored the sperm and the person and the doctor at that time has to decide whether or not to extract the sperm, and then after you extract the sperm, to whom to release the sperm. So in deciding whether or not to extract the sperm, doctors used to, if there's a wife and nobody's objecting, they used to just remove the sperm. And we're finding more and more of those cases dealing with the military wives. Men are going to Afghanistan and Iraq and they're dying, and then you're having the wife, now they make them get a court order to have him not embalmed, to have, because you have to, the sperm is only viable for 36 hours. You have to rush in and put ice on the genital areas, and so having it preserved. And then, but now a lot of doctors have gotten in trouble. In that case, it was the parents that were suing that they didn't want, for religious reasons, sperm taken from the son. So now the hospitals are requiring a court order for the whoever is asking for the sperm to be extracted. So from an ethical perspective, looking at whether or not we should extract the sperm, we're looking at the procreative rights of the man. And I'm focusing up on sperm as opposed to eggs because the vitality rate of frozen eggs are really, really low, and the birth rate is really low. So you find most of these cases dealing with frozen sperm. And then the eggs get out into the issues of surrogacy. And I touch on that a little bit, as I will indicate in a moment, but I didn't want to bring the paper because you can write a whole book just on dealing with surrogacy and the issues that that brings up. So going forward, once deciding whether or not to extract the sperm, we all know under the Davis case, the court said you have a fundamental right to procreate, but you have a fundamental right not to procreate. So people who are objecting to this saying that unless a man has frozen his sperm, and it doesn't matter if they say it's not an invasive procedure, if we're supposed to carry out the person's intent and protect their bodily integrity. If you die, do you just become a piece of property that we can start harvesting parts? And if that's the case, then where do we draw the line? Can we now take your kidney? We know in most jurisdictions now we know we can take your cornea. But can we just start taking other particular body parts where we have shortage and where it's necessary? And the other, from a bioethical concern, is that unlike blood, organs, or other tissue, this has the possibility of becoming a child. And I'm going to talk about the focus on the child in a minute, because I really look at the reproductive rights of the man, but I also focus upon what happens once the child is born. So I look at the preconception issues, and then I look at the post-conception issues. And the preconception issues I'm looking at is whether or not we should even permit posthumous reproduction. Secondly, if we do permit posthumous reproduction, should we limit it to just frozen sperm and not fresh sperm? If we say you can retrieve fresh sperm, the issue becomes, and like the beginning of the introduction that I gave you, is a scenario where the girlfriend shows up for the sperm and then the wife later shows up. So the issue becomes, as the gatekeeper for the doctor's perspective, to whom do we release the sperm without a court order? Traditionally, it used to just be wives and significant others who were seeking to obtain the sperm. But now it's parents. In Israel, there's a whole new type of parenthood called grandparenthood. And it's based upon young men going to the military, dying. They're not married, they're not in significant relationships, but the parents want to be grandparents. And there's a center over there where they created a law what they call grandparenthood. And it's even in this country, There have been some cases. One was in Texas where a young guy was 23 years old. He's killed in a knife fight. And he's just been a kid. You know, he's going to college, you know, drinking, hanging out with his friends, and he isn't, and, you know, he has several misright nouns. He's not trying to settle down, but after he passes away, his mother gets a court order and said he always wanted to be a dad. You know, he even named his children. He said, these are the 3 children I want. So she goes to court and get a court order to get the sperm to be able to create her grandchildren. Now, that opens up a lot of issues because what happens is then she advertises in the paper for somebody to be a traditional surrogate to carry the grandchild. And the cases so far, and it is really predominant in Israel, but so far there hasn't been any type of glitch in the sense that the surrogate is surrendered the child. But the issue that is raised is the age of the grandparents and the rights of the surrogate. And I will talk about it when I talk about the legal issues once the child is born. So everybody's really upset. I don't know if you guys have heard about the case where they paid they offered the surrogate $10,000 to abort the child, and she decided not to abort the child. So you open up a whole lot of issues when you involve surrogacy. And I call that's the anguish part of my paper because it happens so quickly, and it's almost like they're looking for replacements to their children. And the doctors have to decide whether to release or not to release. And right now, if nobody objects, and usually if you have a parent, a young kid, if both parents are in agreement, nobody's objecting. But there have been some cases where the parents are divorced or separated, and they are trying to make a determination who gets to decide whether or not we're going to extract the sperm, who gets to decide whether or not your child is able to create a grandchild using a traditional surrogate. And what role is the surrogate going to play in the child's life? So those are all looking at the reproductive rights of the man. But then I want to focus upon the needs of the children, because what is happening is that there's next to no regulation. There are only about 11 states that regulate posthumous reproduction in any context, and it's all financial. Nobody has a discussion of, whether or not we should create fatherless children. It's all about the financial resources. And a lot of these cases, it ends up being about Social Security survivors benefits, because these are not, the Ann and Nicole Smiths are not creating heirs to, big fortune. They're people of modest means. So you get the issue, and this is where surrogacy comes in, because in the grandparent particular situation, courts have said that a child has to have a legal mother, a legal father. And so what we're seeing in surrogacy area, and in the case I referenced about the surrogate that was out for $10,000 to abort the child, she flees the jurisdiction. And the reason why she flees the jurisdiction is because how the rights of a surrogate, she's a traditional surrogate, varies from jurisdiction to jurisdiction. So the different tests from looking at what does it mean to be a legal mother of the child. And so the first once the child is born, the first issues from a legal and an ethical standpoint you have to address is who are the parents. And if I decide that, my husband is dead, I'm a widow, I'm going to be the sole parent. And that doesn't raise as much issues as if somebody, if I decided I want to have a grandchild, and I'm going to assume that I'm going to be the parent. Grandparents have visitation rights in some jurisdictions statutorily, but there are no states where grandparents have like parental rights. And I think eventually what's going to happen is we're going to start seeing some of those custody fights. A surrogate bonds with the child is going to say, and has never had a connection with the man because she gets acquainted with his sperm after he dies. And I call it a sexless interaction. But look, I discussed the different tests for determining who's the legal mother. Some states say biology. which means the surrogate, a traditional surrogate would have the right over the grandparents. Other states say gestation, so that would favor the traditional surrogate, the gestational surrogate. States like California say it's intent. What did the parties intend? And we're treating babies like bullets, right, or widgets. It's just like, what do you negotiate? And the case that's coming up, I think that's going to end up being a breach of contract case, because they want to say that the child is our property. We don't want to raise it. They're very clear. The kid has so many disabilities, we don't want to raise it, but we would like for it to be placed in foster care. And then you have the surrogate saying, I don't want to raise it either, but I have some adoptive parents that are willing to raise it. So you see how we're going to start treating kids as commodities, trying to determine, I purchased a used car, and I bought it as is, caveat emptor. It has some problems. I can't return it back to the manufacturer. Maybe I can put it on sale. Somebody else will purchase it. And dealing with those issues. And then they look at only one jurisdiction say, let's look at the total circumstances. And let's look at the total circumstances, really getting to the best interest of the child standard. And believe it or not, in all of these cases, that's never discussed. In the Johnson case in California, that the majority said the intent standard would apply. The minorities, the dissenting opinion said, what about the best interest of the child? This is not a widget, it's a child. But the focus of these posthumously conceived children is the focus is on what is in the best interest of the parents. What did the parents intend? With regards to Social Security benefits, I will talk about that in a moment. Adjudicating paternity. I wrote a book last summer that came out on NYU Press dealing with paternity and artificial insemination, showing that children born using artificial insemination and other reproductive technologies are treated so different from children in the same situation that are conceived naturally. And that will bring out that how do we treat posthumously conceived children. And what it seems to is that if we don't agree with the manner in which the child is conceived, then that child tends to have less rights. It's always been that historically we wanted to marry the child that's at the top of the food chain, then then adopt the children because you were doing the right thing, you were adopting people's children, then unmarry the children. They were kind of over here in the second tier, and stepchildren were in the second tier, because clearly if you have an unmarried child, a stepchild, somebody's fornicating and committing adultery and divorcing and doing everything that we don't want them to be doing. And the same thing I think is going with these children born using reproductive technology. We're messing with nature. More and more of these cases involving same-sex couples. And then, we don't agree with them being able to create children this way. And now this is a whole level, because we're talking about dead people's children. So we're creating children from the dead. So I think that the way society is going to view those children, and the reason why nobody stepped up and say, let's don't just do it, it's like a theoretical thing. Let's look at practically what is going to happen to the children. They need parents, and they need money. They need financial resources. We all know children are expensive. Social Security, and these two are blended because the Supreme Court last March confirmed that the state law, intestacy law, determines whether or not you get Social Security survivor's benefits. Most states have said a survivor has to be in existence before the parent dies. So that sort of right there says posthumously conceived children are never going to take on the Social Security survivors program. Even in a state like Florida, where they talk about posthumously conceived children, they say only if you leave a provision in your will giving money to your posthumously conceived child. So in the intestacy system in Florida, your posthumously conceived child wouldn't have a right to inherit. Ohio, make it clear, is a blanket prohibition. If you conceived posthumously, you're not entitled to inherit. And if you're not entitled to inherit, you can't get Social Security survivors benefits and veterans benefits, other government benefits. And like I said before, these are people of modest means, and they're looking to get government benefits. They're not looking to get an inheritance. It's not a matter of somebody creating a child with a real rich man to try to, even though I mean, I might would have advised somebody like Anna Nicole Smith to do that, because then that would have solved some of her problems early on with his existing children. So after I look at, okay, these are the issues that are dealing with, the preconception, the man's reproductive rights, and the post-conception, the best interests of the children. I think we have to figure out a way to balance those two things out, and that's what I'm researching now. That's what I'm looking into. How do we have a happy medium where we're protecting the reproductive rights of the dead and also taking care of the needs of the children? And in taking care of the needs of the children, I'm doing looking at the best interest standard, but not a traditional best interest standard, because this is different from the criteria of best interest of the child. Usually is when the child already has two legal parents and you're trying to decide which parent is fit, and you go through these criteria. This is somewhat different because it's determining the initial adjudication of the parents for the child, and also the financial resources. It's always in the child's best interest to have financial resources. So I think that on the scale, what I'm going to probably come to is that the benefits of children should outweigh the benefits of the grown-ups. But then I've had people counter and say, well, we see if the person is alive but the person is dead, isn't a dead person just as helpless as the child? But then I go and say a dead person is dead. Once you're dead, you're dead. But one thing the court has pointed out in these cases that made me think that it's not just once you're dead, it's the impact it's going to have on the existing children. So if the man already has two children, and he's worked hard, and he doesn't do well, but he wants his inheritance to be split between his two children, and now his sperm is used to create 8 children, that's negatively impacting the 2 existing children, and also going against his intentions, because these are not children that he has a connection with, are children that he knows. But I want to look at best interest of the child broadly. Um, the test now considers just like the mostly physical and psychological. But even like when I used to do family law, and I used to do custody cases, the court never really considered, it did, but it never really said we're looking at the economic best interest of the child. So I think that has to be thrown in the occasion. And looking at the reproductive rights of the dead man, I think the first challenge is going to be how to frame what sperm is and what is, from a property perspective, what's the bundles of sticks, right? Because if it is treated just like any other piece of property and you have a right to exclude, then nobody should be able to use it without your permission. And then I'm also going to look at some of the informed consent jurisprudence. So any ideas that you guys can share would be great. Yes.
What about filing corpses and things like that? Don't they apply at all to this situation? I mean, is it because this is characterized as a medical procedure rather than desecration of the corpse?
Exactly, because I looked at those statutes. I had my research assistant do some research on the law of the dead bodies, what happens. So when you read, most jurisdictions say there are certain ways you can treat them. And for some reason, they're saying that this is, since the doctors are saying it's a non-invasive procedure, we do it humanely and with dignity, that is somewhat different than me just cutting up a corpse on the side.
But I do think that there is a way in which the fact that this is classified as a medical procedure obscures some of the ethical issues that are involved there. And it's a way, like when doctors do things, we tend to think of them acting in an ethical, professional manner. So I think one thing you might ask is why is, regardless of what they say, is this truly different? I mean, why is this different? And the other thing that I was thinking was the Convention on the Rights of the Child. It mightn't be, if you were to actually look at the Convention on the Rights of the Child, that you could argue that there's a good argument why this should never happen, given the best interest of the potential child. If we're applying, and Barbara can probably speak to this more also.
it's better for the child not to come into existence than to come into existence under this particular arrangement.
I think, I'm trying to think if the CRC would apply. I think the CRC has tried to stay away very much from taking a position on at what point the right to be alive attaches. But the thing that troubles me here is this idea that children do have a right under the CRC to an identity and to contact with both of their parents. I mean, there are a lot of built-in concepts that are assuming that there are going to be two parents available, and also that the identity of the parents is going to be known.
So in the system, if we were talking about an anonymous sperm donor, that they would still have the right to know?
That, I think there's a conflict between the CRC. I don't know if anybody's ever tried to adjudicate it, but it seems to me there's a conflict between the CRC and the concept that anyone can remain anonymous, similar to the idea of closed records in adoption. Children have a right to knowledge of where they came from.
Well, certainly in Canada, though, we push that around anonymous donor sperm, is that our sense that identity is something that is medically concerned when it has to do with children that are from donor-assimilated backgrounds. So rather than assuming that identity is genetically transmitted and that we don't know our biological heritage and somehow missing some social identity, there's a recognition that genetic and social identity are actually quite different. We conflated them, but that they don't have to be the same. So a child has a right to a medical background, that they have a right to know if there's like some sort of disease or some kind of congenital issues in their history, but they have there's no intrinsic right to some kind of notion of identity that's based upon purely on genetics in a way that is actually socially constructed. There's this case right now going before the Supreme Court that is trying exactly this in Canada, but I think this is the way it's going to go. Because otherwise we will only allow anonymous donors in Canada, and I personally think that's going to be quite a chilling effect on the amount of donations that we're getting tonight. Sorry, not anonymous, but only open ID donors, which is a mistake. I had a question. I had a hard time envisioning some of these thought experiments you were doing. You know, I was trying to imagine like this people of modest means that had like 2 children, right? And then suddenly there was 8 children created, and they were then vying for the inheritance. Like it's in my experience, people that hire for surrogates, they're quite wealthy. I mean, like it's not like that's. It's not like you can just go and use the sperm and create multiple children without.
Oh, no, I wasn't thinking, because the surrogacy comes in when you have the grandparents, and you're right, though they have resources. Because even if they're not quite wealthy, they have money that they would use for the children's college fund or whatever. But I was thinking from the perspective of majority of these cases are wives or significant others just wanting sperm. And all the cases where we've never had a case adjudicated where the person isn't asking for inheritance. All the cases come about because the persons are applying for Social Security survivor's benefits.
I guess there's a case that I know in Canada where it was a gay man who died, and it was just a friend of his who was a lesbian wanted to use his sperm around to inseminate, and the family prevented that from happening. So that's the only one that I know that's actually not a trial, but it seems to bring up quite different issues from this, again, presumption of having a 2-parent family as being the only model or necessarily the best model, that when you think about how queer families are creating structures that maybe aren't only 2-parent, it could be 3-parent, it could be 5, it could be 1, you know, I think that when we look at these technological interventions from a model that I think allows us to maybe get outside of the necessity for having this dyadic structure of parentage, it might help us think through some of these complicated biological questions, which aren't in any way actually related, I think, to traditional notions of what family is supposed to look like.
Well, I discussed that a lot in the book I wrote on artificial insemination, and that's the solution that I come up with. Because the Supreme Court has said you can only have one legal father. And so what I say is that we should start reflecting, and that's part of the psychological best interest of the child, is reflecting the relationship that the children have, be it 2 or 50. And And there's a criteria. A professor has like a 3-part test. There's a de facto parent. What is the de facto parent? What is the psychological parent? And then I do this tier that says that if the goal should be that the child has as many parents as possible, right? Too. I understand the 2-parent model is better because it's difficult for, like, if we all had one child, it would be, and we had to decide where the kid is going to school. There are 1, 2, 3, 6 of us. That makes it more difficult. But on the other hand, the child would have more resources. But I'm saying at least, 2 parents. And how do you get there is I think what I disagree with the law. And I don't think you have to get there by biology. I don't think you have to get there by tradition, like, to the mother, the dad, and the wife picket fence and the dog. But I grew up in a culture where a village truly raises the child. So everybody, I grew up in the South in an African American family where grandparents lived in the home, and grandparents had the same input and say as your parents. So you were raised by 3 or 4 people. With my sisters, my nieces and nephews are always lamenting the fact that they're raised by separate people because we all have input, even though they're not our children. So I agree with you. And I think that when I'm looking at the needs of the child, that's one thing I'm going to consider. I may expand that chapter in the book in this particular context, looking at posthumously conceived children, that even more so than children conceived using artificial insemination, that they need this. And what I think is coming up is, I don't know if you're familiar with the case, I think it's in Texas. Well, there's one in Texas and there's one in California. The one in California is where, I think it's California, the 2 women decide that they want a child. They live together. They both save and pay up to do the procedure. One person gestates the child. The other person donates the egg. And they buy the sperm. And when the child, it's this child called Mom 1, Mom 2. When the child is 4 years old, one mom has a conversion. She joins the church, and then her church teaches her that, this is not right, this is sinful, so she doesn't want the child to have any connections with the second mom. So they separate and they go to court, and the court awards custody to her and just says the second mom had to have visitation. She refuses, so the court transfers custody to the second mom. But by that time, the church has gotten her to Nicaragua. And I think that's been going on now for 4 or 5 years. Nobody's finding, and I don't think they will ever find her, because I don't think anybody's looking at her. And because I think the woman here has limited resources. Yes.
No, I was going to change the subject.
Oh.
If you're done. Let me try to re-articulate what I was trying to get at before with using the Convention on the Rights of the Child. What bothers me about this case is what it says about the way that we view children as a product and as property. And also the idea, what this also reminds me of are those situations in which you use, not you, but one uses assisted reproduction technology in order to produce a second child because the first child is dangerously ill and you need whatever, donation, organ, all of that. It is this, it reminds me, and if you haven't read Never Let Me Go, you really should.
Okay, Never Let Me Go.
Never Let Me Go. It's about children. It's by, he's the same person who wrote Remains of the Day, with whatever his name.
Forster.
It's a novel.
What's it about?
Whatever his name was. I thought it was.
Oh, it's a movie?
No, it's.
Well, they made a movie of
It's
it,
a
but
book.
yeah, it's E.M. Forster.
No, and then it's the wrong.
No,
It's going to the wrong one. But anyway, I'll find it for you.
Okay.
But it's about children who were produced for their. As it turns out, when you get through the novel, they're produced as organ donors.
Oh,
And that's their
wow.
whole purpose in. And this, it just reminds me of that situation. So, and like, if you were that child, knowing that you were produced, for example, to replace a lost son. So the grandparents lose this son, and what they want is to, you know, to have his child. The position of the child in that, I think, is, for me, like ethically problematic. So that's, maybe that was clear what my objections were.
And interestingly, just following up on what you just said, but then you say actually that, I mean, if you produce a child to help the already existing child, I mean, heterosexual healthy couples would be able to do it anyway, and then we would not allow it because we involved some technology that maybe allows it in, and that's I think also here is a little bit problematic. Maybe I will be playing the advocate's devil now a little bit, but of course it's a very different situation in a posthumous reproduction. But if we talk about the sperm donors and the enormous migration of sperm, then the sperm can be often used posthumously without even knowing that we're using this sperm from a donor that passed away 10 years ago, and there will be also no possibility.
Oh, okay, wait a minute. So I didn't catch the last part. So you're saying that
If the sperm donor under a traditional arrangement has died, it's posthumous reproduction, because they're you know.
oh, so if you go to a
sperm
sperm
might be
bank,
frozen.
oh, I didn't think about that.
But the difference is the anonymity. And here, it's the people who are seeking to do this have a relationship with the dead person, and that's what brings in this notion of, you know, substitution for the deceased person. And there is actually technology involved, at least in the situation where you're reproducing in order to affect or to save an existing child, and that is that you need to be sure that the embryo has whatever it is that's necessary for the, so there is technology involved in that too.
But it doesn't have to be a replacement. I mean, in this case in Canada, I mean, this gay man didn't have any children. He went into chemotherapy, and so he had banked his sperm before he went to hospital, and then he currently died, or sorry, subsequently died. And she wanted to use this because she was planning to have children anyway. She was already looking for a donor. This was her best friend, and it was a way to memorialize and to have, you know, to in the same way that when we love someone in a heterosexual relationship, we want to have some of them to carry on our legacy. It was the same sort of idea. So I don't see it as being necessarily
No, I don't think it is necessarily. There might be people that go into it with pure motives.
Yeah.
I'm just saying that you know, again, we've got to have a rule that applies to all cases.
But I'm always suspicious of this move when we go from like a natural reproduction where heterosexuals can just magically create children under terrible circumstances, and we would never suggest that we should regulate heterosexual reproduction because that's what people have to do. But somehow, well,
That's what I was just about to
we
say.
no longer sterilize in the ways that we
No, but people suggested regulating it. Like, for example, with AIDS, they've suggested putting an age limit on who can go and do in vitro.
No, but I mean, we don't regulate heterosexual natural conception. But yet, when it comes to
But yes, we do though.
Well, how do we stop from having?
Well, there are laws on the book, because I'm actually working on something called the criminalization of sexual behavior. We do that in this country all the time. Fornication, adultery, sodomy, prostitution.
Right, but my question is, how do we prevent heterosexuals from having children? Do we do this?
And we do, it depends. If you have an outright law that says, you know, whatever,
No.
but non-traditional reproduction, even among heterosexuals, is punished, it's sanctioned in a variety of different ways.
But it's not
Through
prevented.
all the legal regulation, is a real disincentive
Yeah.
for people to reproduce. And actually, it was proposed, and has been many times, that if children are born to single mothers, for example, well, actually the policy is still to do this, I believe, that to actually prosecute them for if they don't claim the father to go on the birth certificate,
Oh.
for example, things like that. I mean, there's all sorts of rules.
There's a whole list, because now they're making a condition of probation. Like there was a woman who was a crack addict. She was arrested for crack, and the judge said you can get out of prison, but if you ever have another child, then you're gonna have to serve your 2 years time. Welfare reform was about restricting sexual behavior among heterosexuals and procreation, because you can only have like so many children on welfare.
No, I completely hear what you're saying, and of course there is a world of sexual regulation. The point that I'm making is merely that the actual act of coitus between a man and woman that can produce a child is something that we don't regulate. While because we have technological frameworks that allow these things to be so-called recreated, then there's a whole host of structures that come into place and a whole frame of.
And see, that's what I'm disagreeing with. I think we regulate sexual behavior among heterosexuals.
We're saying people can't do this. We're saying maybe we shouldn't let posthumous reproduction happen at all. Right, which is something that's quite different from saying we're going to let this happen, but then there's going to be all kinds of disincentives to actually do it in the first place. So folks might not choose to, right? But this they won't even have the choice to be able to use that sperm because we're going to stop it from being in circulation.
Stu, I would say we shouldn't allow people to have to use technology to have children to replace organs in their existing children either.
Mm-hmm.
I mean, it's not a matter of, it has not, I just don't think, and and the pregnancy might come about natural ways, but the technology is going to be used to see if in fact the genetics are there, or, or you have whatever it is. I don't even know.
And the big concern people have in this are the grandparents that are coming in, and let's get to what you were saying, is that people are comfortable with the significant, even in same-sex relationships, people are very comfortable with using this technology, harvesting dead men's sperm to implant it in whatever. But people are really uncomfortable when we start creating grandparenthood, where the grandparents are creating substitute grandkids, because they're saying, my child could never have a child, and I deserve to have a grandchild. And I'm actually going to do a Fulbright, 2-week Fulbright specialist in Israel in December to talk to this woman, because she's got a whole legal practice based on the fact that you have a constitutional right in Israel to have a grandchild. And so so no matter what, because whereas in this country we regulate how many times you can go through in vitro, and I think the doctors in here says that 4 times, I think is considered extreme. In Israel, there are people going through it at least 12 times. And even, there's the surrogate situation, but there's also the situation where the man had a wife. And now the grandparents are putting all this pressure on you have to produce a grandchild. So she's going, ultimately, we don't know what it's going to do to her body going through 12 rounds of in vitro. But there's no limit, there's an unlimited number, because the whole thing is ultimately to have the child. Yes?
It's a different topic, because you was mentioning this vulnerable people that are in military and are more susceptible to die before they will be able to reproduce. And knowing that, are there some provisions or something that you can sign now in military or in Israel that will regulate your posthumous sperm?
Well, what is happening in the United States along that line is that there are 2 companies, and probably more are going to get in it, that are actually contracting with the military to do this. Like when they set up there and they before you go to war, they draft a will for you and advance directives and all. And now they're removing your sperm at that time. They're saying it, and by the way, if you're married, your wife, you probably won't, you may not come back. And so now that becomes an industry. They're contracted with the military, and so they're storing sperm, and so they're making sure it's documented, so they're removing the barriers for military wives to get the sperm, because they're taking it in advance. Brave new world.
It's also, it's the rejection of fate. I mean, in a way, it's like the notion that you can, what it says about the medical profession, what it says about capitalism, which is, it's all the wrong instincts.
I think that mean, what technological reproduction allows us to do is to denaturalize heterosexuality. So no longer is that the only, the proper mode of reproduction. Right? It gives us totally different ethical, biological, and I think imperative frames to think about when we have taken away, we've decoupled that necessity. So I agree we need to have difficult conversations and different conversations, but I think it's important that they don't come from a premise where we're still trying to recreate a heterosexuality. Right? The idea that there would be grandparents as opposed to like loving parents, that's where the problem comes. Right? The military wives, that's okay. Obviously there's a loving wife and this poor man that died in battle. You know, it's recreating a certain kind of heterosexual script, like it's quite normative. Where when we have grandparents involved, then suddenly it becomes like something's intergenerational, terrifying, or where are they gonna die, and then the state's gonna have to take care of these kids. Like that's where I think the capitalist argument is.
But I think the big problem I have with always the children are never brought into the conversation. Even with our conversation, we're talking about same-sex couple, heterosexual couples, grandparents, such and such.
I was talking about the children.
Yeah, you were done with the children.
No, because,
And I think that there's not enough discussion to talk about the children.
But I think we need to shift that frame first, because I mean, the reason that same-sex couples weren't allowed to do this for so many years is to presume they wouldn't be good parents, right? So, so a best interest of the child discussion in that case would have said, no, we don't want to do this because those parents are not going to be good, like they won't be acceptable parents. So until we like change the models we're using to talk about it, like we're going to make presumptions about the well-being of that child based on our existing assumptions about what families should look like.
But we do that, and we've done that for years, and it's not just about sexuality, at least in the United States. Because right now, in a lot of jurisdictions, you can have a same-sex couple, you can have a low-income couple. They're always going to say that the same-sex couple can do a better job of raising a child than the low-income couple, especially the low-income couple happens to be brown.
No, absolutely, absolutely. But that's recent.
But I think it depends. I mean, where do you want to draw the line? In the Netherlands, wasn't a case that came to court. We didn't go to court that often, but a couple was doing IVF, and the husband was diagnosed with cancer, and the IVF wasn't successful, and when the doctor said, well, you have just only a few months to live, then the fertilization clinic said, well, it's immoral for us to go further with the fertilization because we know that the child will be born as an orphan. So, I mean, you can say, well, there is somebody is already dead, but he will be dead in a year. So,
see, I'm of the mind that, and I talk to a lot of people. People seem to think that they have a right to have children. I know that they say constitutionally you have a right, but I'm just saying from an ethical perspective, you don't have a right to a child. Child's not, you don't have a right to a child. You don't deserve a child. It's not all about you. And unfortunately, the more and more people I interview about this and in artificial insemination in general, matter the heterosexuals, same-sex couples, is all about them. I deserve this. I want to be this. They trying to stop me from, okay, you don't deserve anything. It's not a widget, it's a child. And so I think that we have to start rethinking the entire conversation. But I am going to look for the convention. I didn't know about that. And it's the convention on the rights
On the rights of the child.
of the child.
The reason you know about it is because there's only two countries
Oh,
that signed it. One is the US and the other one is Somalia.
The United States signed something?
No, we haven't ratified it.
Oh, we're the only two countries that haven't ratified.
Yeah, it's Somalia and the United States.
Somalia, yes. Okay, good company.
I'm just wondering, like, when we're talking this, maybe we've talked, but I mean, going back to the children's rights perspective, like talking about this in an international context, I believe like everyone, this is my belief, it's everyone is born with his destiny already or her destiny already written somewhere. Okay, so by interfering in this and transferring, distance or changing this destiny, like by using the reproductive technology and donating sperms and doing this kind of practice, are we intervening in the children's rights even before they were born? Like to actually changing their biological parents by doing this? Like, okay, I have this, for example, I want one child born to a specific person, and then this person, before he was born, actually he donated his sperm to another couple. Okay, I mean in doing this, are we already denying the children rights before they were born? Like, if you get my point, I'm trying.
I see. Yeah. And
God, yeah.
and actually, that's been a problem, not just with children you born using reproductive technology. Like I was saying before, we make judgment about the rights children are entitled to based upon the families that form them and the manner in which they're created. Because we think that the destiny for married children, that's why they're at the top of the list of everything, right? You know, in any inheritance systems, in any government benefit programs, you're right, with the military wives, because their wives and their husbands in the military. But if you have a woman who's even in a having sex naturally, if you have a woman who decides, I want to be a single parent, I have a friend, he's willing to donate sperm and I can do it artificially or naturally, already that child is down on the end, right? Because that child is a child born out of wedlock, you know, used to be considered a child of no one and couldn't even inherit from the mother. And so I think you're right. I think that the discussions that we have about how children should be conceived are tied to the fact that we think that it should be a two-parent model in a family with a white picket fence and a dog on the side. And anything that's different from then, you know, because like stepchildren, I mean, they don't, you can have any type of relationship at all. I mean, I was raised with, my dad was my mom's second husband, and I didn't even think about it. You know, my brothers and sisters were my brothers and sisters. But when my parents died, that was the discussion. When we looked at who's going to inherit the property, that even though my dad raised them since they were like 2 or 3 years old, they don't get an interest in it. And what's the difference between me and them? I was born in this, you know, this two-parent arrangement, and they were the result of something that went wrong, the first marriage. So I agree wholeheartedly. When we have these discussions, we are already disadvantaging the children. And so we include them in the discussion in the wrong way, in the sense that we don't include them in the discussion about recognizing relationships and thinking of what a family means broadly. And we are, a lot of times we're all guilty of that, because even when we classify on the income tax or for benefits, we don't classify single people as families. If you're a single person without a child, they'll say you don't have a family. I'm a single person without a child. I consider myself a family. I have a life. I'm a family. I'm a single person family. But you're right, it's that definition of family. Well, thank you guys for the great comments. It's going to help me out tremendously.